All right. Good afternoon and welcome to our HR in the Law Q&A session. This is brought to you by the HR Certification Center and the HRCC Consulting Group. This series is designed to provide a practical platform for discussing key legal issues surrounding human resource management and workplace governance. Our aim is to amplify complex legal concepts and translate them into actionable insight for HR professionals, business leaders, and managers. Now, if you are online with us, we would like you to introduce yourself with your name, the country you are joining us from, if possible, your role or profession, and a brief expectation, what you're expecting at the end of this session. And to our friends who are online, I would like to see you comment or putting your comment in the comment section with your name, possibly the country you are joining us from, your role or profession that you are in, your expectations for today's session. I'll be grateful. I want to start seeing some chats coming through. And I also want to have the privilege of reading it out for others to get to know us. But whilst you're doing that, if you would like to ask a question in the course of the session, please, for us to be able to separate questions from comment, we would like you to start with Q and A, colon, then you continue with your question. Or QA, colon, then you continue with your question. I can see Martha. I can see Michael from Sierra Leone. I can see Wisdom from Jasikai. Yes, Jasikai Republic. Yet I can see Ida Jao from Ghana. Thank you very much for joining us. Marietta from Ghana. And please do also add what you do. I am Joseph, excited about this topic today, as it clearly highlights the link between responsibility, control, fairness, and workplace. Yes. Thank you very much. Christabel from Ghana, Georgina from Ghana, Enoch from Kumasi Republic, Stephanie from Ghana, Roberta, Cynthia. I can see Pistol also here, who is from Ghana, HR officer, Setters Investment Company. That's nice. We're talking about insurance companies some time ago, so I hope we can see some of the insurance companies join us. Ophelia from Ghana. Okay. Senior Edo from Ghana. Ida from Ghana. Felicity from Ghana. Thank you very much. Just keep it coming. Portia, Benedicta. I'm waiting for my Nigerian people. Yes, Dennis from Ghana. Where are my Nigerian people there? We have Sierra Leone, we have Ghana. Ebenezer from Twellium Industries, Kumasi. That's nice. Cynthia, Industrial Relations Administrator. Dennis from Ghana. Samuel from Ghana. Thank you very much. I'm looking forward to all your questions and an insightful interactive session. We'll be going into our conversation very soon. I can see Pearl from Ghana, Louisa from Ghana, adding the Ghana flag to it. Andrew from Ghana. We are at 83 people joining us live. Let's see if we can get to 1,000. Anyway, all right. Hannah also from Ghana. All right. So I'll start the conversation with a brief statement. Then after that, I'll introduce our facilitators for tonight's session. Then when we're done with the session, we'll just go into a Q&A where we'll take all your questions and then our facilitators will answer them. Unfortunately, we have experts on the subject matter with us. All right. So Portia from Ghana, Ferguson from Ghana, Fifi Sam from Sam Ed Consults. All right. So good afternoon once again, distinguished participants. In today's business environment, risk management has become an integral component of organizational sustainability and governance, and that's why we see a lot of conversation on risk. For HR practitioners, business owners, and managers, understanding legal risk is no longer optional. It is a strategic necessity. This webinar is designed to equip you with practical and applicable knowledge on vicarious liability in the workplace. And at the end of the conversation, you understand why, if an HR manager is creating risk indicators, he has to look at vicarious liability as part of the risk indicators in the organization or as part of its risk analysis. Our focus is to deepen your understanding of how and when employers may be held legally responsible for the actions of employees under Ghanaian law, and what this means for HR practice, leadership decision-making, and organizational policy. Now, I mentioned Ghanaian law. Yes, that's the context of the conversation. But, I mean, in the conversation, I'm sure we may also give some clarity on best practices in the conversation. We will examine the legal principles, explore real work scenarios. I'm sure we have facilitators who are industry players, so I know they'll be answering some few examples. So we have scenarios and discuss the practical steps organization can take to manage exposure, ensure compliance, and implement preventive controls. What are expectations? By the end of this session, participants should be able to clearly define what vicarious liability is and distinguish it from personal liability, identify circumstances under which employers may be held liable for employee actions, assess workplace risk that could expose the organizations to legal claims, implement practical preventive measures, including policy strengthening, training, supervision, and documentation controls, and be able to apply Ghana and best practice in real work situations with greater confidence. For us, we anticipate a highly engaging and practical discussion that will strengthen your legal awareness and enhance your capacity to manage workplace risk effectively. Now, to help us with this conversation, I'll first introduce a big gentleman who also happened to be my lecturer. So I can confidently say he's an expert in that area. He is in the person of Mr. Kofi Oti Edinkra Jr., an accomplished legal practitioner with extensive expertise in employment and labor law, commercial practice, regulatory compliance, and dispute resolution. He holds LLB and LLM degrees and is a qualified barrister and solicitor of the Supreme Court of Ghana, and is a certified mediator arbitrator with the National Labour Commission. Kofi has advised multinational corporations, and the qualification I mentioned above is just a summary. There are a lot. If I decide to go through it, I don't think we will start the session anytime soon. So I'm just giving you the summarized version of who our boss is. So Kofi has advised multinational corporations, public institutions, and international organizations, including the International Labour Organization, that is ILO, the World Bank, GIZ, and GIZ on legal compliance, labor relations, and governance matters. He has also played key roles in legal reforms initiatives in Ghana, including participating in the validation of the draft of the Labor Law Bill 2024, and he also made some contributions to the review of the Constitution during, I think, 2010. Yes. Beyond practice, he is an experienced academic and currently serves as a faculty member at the University of Professional Studies Law School, where I also did my LLB, where he teaches labor law, industrial relations, and among other subjects, including contract law or law of contract. With his deep experience in employment litigation and regulatory frameworks, he brings both practical and academic insight to today's discussion on vicarious liability and employer responsibility in the workplace. His academic areas include labor, industrial relations, private law, and as I said, company and partnership law. Without saying much, let us invite our big man, Mr. Kofi Adinkra Jr. Sir, you're welcome.
Papa, you've made me shy. This is too much.
This is the summarized version. So
Please. Thank you. I'm glad. I'm happy to be here to discuss this important topic.
thank you very much, sir. I would also like to introduce our next facilitator. And for me, I affectionately call her Auntie Yvonne, or aka Ama Diepena. Yvonne Ama Diepena Radio Public is a distinguished strategic HR and training consultant with over 19 years of leadership experience across various sectors, including energy, finance, shipping, telecommunication, and media. He cuts across almost all the industries. She cuts across almost all the industries, so we are in safe hands. She transforms HR departments into strategic business partners, specialized in HR diagnostics, policy design, performance management, and compensation structuring. She is known for building HR functions from ground up and driving organizational excellence through people. She is a certified professional coach and instructor for SHRI, and then PHRI at HRCC, and CIHRM programs. She delivers high impact training in leadership, professional development, and HR certification. She holds an LLM in labor law, so we are in safe hands, holds an LLB, MBA in HR, and BA in arts from UCC. Being a risk certified senior HR professional and a fellow at the CIHRM, a member of ACHRs with other certifications, she combines legal expertise with practical insight to build ethical, compliant, and high-performing organization. Now, Yvonne currently leads human resource department at a public company in Ghana, having previously led HR and admin at MSC Shipping, Data Bank Group, and CMG. Aside from the above, she leads an HR firm, H4 Factor, where she supports the HR needs of small SMEs and individuals with their career needs. She also leads the Takoa Foundation, which I know she's so much passionate about, an NGO that empowers young girls and their families in rural communities through her PAD project and other donations. And so you can also support her. She is married with kids and loves farming. She loves children and having fun. That one I can rest assured. She loves to be called Ama Adiepena. Auntie
Thank
Yvonne,
you.
you're welcome.
Thank you, Papa. Thank you so much. And thank you for to our audience for making time at this time of the day to be with us. It's a great honor to come your way to discuss this important topic that has relevance for us as workers and for the HRs and leaders here for you as well. I'm grateful. Thanks.
Thank you very much. So the conversation will be it's going to be in 4 segments. But before we go into our conversation, I would like to take a minute comment on the subject, a minute introductory comment on the subject from us. There's a balance that says ladies first, so I'll take Auntie Yvonne first. Yeah.
Let me enjoy it. Ladies first. So when you told me about the topic, this Ghanaian proverb came into mind. "Ọkụtrẹ kọrị n'imeko na apọnkyerẹ ni ati mfifiri." The lizard will chew the pepper and then the frog is the one sweating. Basically, that's vicarious responsibility. The fact that you have a relationship with a company, uh, based on a certain contract, your actions or inactions can, the company can be held responsible. Yes, we'll delve deeper, but in essence, that's what this is about. Imagine a staff in a bank who goes to give a loan to a client and tells the client that this loan, I'm giving it to you at 10% interest. The client agrees, signs on the loan, takes it. Then after some time, this staff resigns, another staff is in that position and is saying it's not supposed to be so. You can't change your mind because that person stood in the capacity of the company to transact that contract. Yes. So in essence, that's what today's discussion is about. So that's my initial take. And I want you to remember the proverb again: the lizard chewing the pepper and the frog being the one sweating. The lizard being the staff and the frog being the company. Yeah.
Thank you very much, Auntie Yvonne. Participants, I told you that we're going to have a lot of practical examples, and you just got one. Thank you very much, Auntie Yvonne. Kofi, sir, your preliminary
Yes.
comment.
Thank you. And since you introduced me as a lecturer, and since Auntie Yvonne has given us the practical side, they will not be surprised if I give a book long introduction. So it's a good afternoon, everyone. So this initial comment is just to set the tone or the context for today. So what the first thing we need to recognize is that the relationship between an employer and an employee in Ghana is no longer purely a private contract because it has profound public consequences. And if I refer us to our own constitution, our 1992 constitution, it guarantees every worker the right to work under safe and healthy conditions. Everybody knows that. Now, vicarious liability is one mechanism that enforces this mandate, this constitutional mandate, and we've seen from recent cases such as I don't know how many of us have followed the case of Kodua Pia and Kwabna Nani, where the Supreme Court started or increasingly recognized or prioritized public safety and what I would say the socialization of risk over instead of technical employment definitions. So when something happens, we are very quick to try and shift blame onto someone else. But
Yeah,
what this means is that the court is prioritizing the socialization of the risk, prioritizing public safety, holding you accountable, even if you want to stand under a technical definition to escape liability. So things like this I ought to be looking at today, and I'm hoping that today's program or today's webinar will move us from from having a reactive mindset where we only worry about legal consequences after an accident occurs to a proactive one.
yeah.
And also as we listen, in on this webinar, let us also do so with a mind to afterwards go and align our respective internal HR policies, align it with the Labor Act and the Insurance Act. Although I know Auntie Yvonne has something on her heart about insurance, which she would say. Yeah. So these are my initial comments. Thank you.
Yeah, thank you very much. In fact, the case you mentioned just reminded me of the Mim Timber case, where the court also relied more on the safety than the
Yes,
the
technicality.
technical. Yes, and thank you very much, guys. We are looking at being proactive and not reactive. Thank you very much. So I would like to ask. So I'll take it. I'll ask Kofi. I would like to know what is vicarious liability in the practical sense, and why is it significant in the workplace context? I know you've
Okay.
had a bit of it, but we want to really
Right.
zone into what it means.
Yes, that's an important question to start with. So, if putting it simply, vicarious liability, first, it is a strict form of secondary liability. So, it is a strict form of secondary liability. What it means is that the employer, if we are explaining Auntie Yvonne's initial proverb, it means that the employer stands in the shoes of the employee for wrongs that were committed at the workplace by the employee. So that's how it becomes secondary. So the employer is not the one who committed the primary offense, but he holds the liability. That's how the secondary comes in. So unlike personal liability, which requires you to prove your fault, prove a direct fault. For vicarious liability, it only requires proving the employee's fault, and that the fault or whatever they caused was done whilst they were doing their job. Whilst they were doing their job, yes. It is one of the principles of joint and several liability, because you have an employer, you have an employee, and only one of them committed the offense, but both of them are held liable. So what it means, vicarious liability means, is that an injured person, a victim, let's call them a victim, they can sue the employee, the employer, or both of them for 100% of the damages that have been caused to them. Um, that is vicarious liability, where the employer is held responsible for an act that they did not commit directly, but that they are responsible for, as long as it was committed by their worker during employment, during the course of their employment.
So, cost of employment. I'll come to you, Auntie Yvonne, but maybe let me stay on Kofi a little bit. Cost of employment. Can you break it
Yes.
down for us? Yes. What is
Yes.
cost of employment here?
Yes. So, course of employment means that the act was committed either at the workplace during working hours, or whilst the employee was working, even if they were working outside the premises. It depends on the nature of their job, because we have different. Some are drivers, and nobody drives in circles at the workplace, right? So it should be whilst the worker was doing their job. And I want to make this note, that even if they were doing it, they were doing the work improperly. That's between the employer and the employee. It's not the victim's matter. It's not the victim's matter. Once it was done in the course of work, whilst the employee was working, then vicarious liability, we can argue that, we can say that it applies.
All right. Thank you very much. So, Auntie Yvonne.
Let me give you an example, but I don't want to make it too, too tech. But there's a case. I don't know if
Okay.
you may be available. You may be aware of the case. Agogro and Ago and another. It's an old case from
Okay.
1973. The one was a driver. A bank driver picked up a passenger against policy. Yes, against policy. But the court held the bank liable still. So even if you did something improper, you can still be the employer can still, be held liable. That's all that I'll add. Thank you.
Thank you very much. Thank you very much. In fact, the scenario you gave us, and it's an example of a scenario in the course of advertising the program. Somebody asked that question, so we even put it on our flyer, where a driver
Oh,
was sent going somewhere, jumped the traffic light, and then hit somebody on the road. And the question is, who is liable?
yeah, yeah.
Yes. So thank you very much, Kofi. Auntie Yvonne, so
Yeah.
how do you separate personal liability from vicarious liability? Because you understand that vicarious liability is the action of the employee in the course of work. That action, the employer is held liable of that action of that employee in the course of work. So how do we separate that from personal liability?
So, in simple terms, vicarious liability, the company or the employer is held responsible for the employer's actions. And then the personal liability, the person, the individual is held liable for their own wrongdoing. But there's a certain nuance here that we should understand, and I'm happy we have this difference, because there are some actions that may lead to both the vicarious and individual, where the company is held liable and the individual is also held liable. And there are some that is only the company, there are some that is only the individual. With vicarious liability, the responsibility is on the employer, but with the individual, it's on the individual. So let me give one caveat to understand this. Kofi was talking about the cause of employment. So with vicarious liability, we need to know, do you have a contract of employment with the employer? Do you also have the authority? Have you been given the mandate to do what you are doing? Do you have adequate leadership training? All those soft things that comes to doing your work, that everybody knows this is yours. Okay. Once you have that, whatever you do during the working hours on the premises or outside the premises, or during a work event, your actions or inactions can lead to vicarious responsibility, liability, sorry. And so it shifts the liability from you, the individual, to the company. But if so, let's say we have a staff dinner, and then in the course of the dinner, I touch you in a way that is not right in my capacity as HR manager, you can sue the company and also sue me. With the company, it becomes a vicarious liability because I'm a representative of the company. And you are suing me in my personal capacity for doing that, and that's the individual, the personal liability. Then vicarious liability happens when, in the course of employment. Once again, Kofi has explained this, so I won't go back there. But personal liability can happen when either within the course of work or typically outside the workspace. So let me use the staff dinner again. We've done the dinner, we have finished, everybody is going home, and then in my taxi home, I have a brawl with the driver, and in the process knocks out one of his eyes. It's a personal liability thing. But even that, if you get somebody who gets a very good lawyer like Kofi, your personalness will be put aside. And it is you, the company, that will be brought into book, because it was your program they attended that they were going home that it happened. So this is why these days we have the out of office conduct policies, managing how people should behave as employees, even outside the workspace. Yes, because of the thin line between vicarious and the personal liabilities. Another difference is that with vicarious liability, the employer pays the damages, even though you are not the direct person who caused it. Okay, but with the individual one, the individual may pay it. Okay, yes, the individual may pay it. So Andy, the course of employment, we are talking about the fact that the action took place within the working environment or working time in your capacity as a worker or somebody authorized by the company to do that. So that's the cause of employment. I think Kofi can give a better legal explanation on that one. Yeah. So in essence, that's the main difference between the vicarious liability and the individual. Let me give a typical example. If a supervisor sexually harasses a staff during working hours, the supervisor may face personal liability, and the employer can also come in. And this brings me to the case of the First Atlantic matter with the Ntiamwa CFO and the National Service lady. So they were doing this in their personal capacity. Initially, the lady wanted the company to be held liable for the actions of the CFO. That's the vicarious liability. Thankfully, the company was able to prove that they had taken reasonable caution, so they were exonerated from the case. And in Tiamwa faced it in his personal capacity. So it became a personal liability and not a vicarious one. Yeah.
Um, I don't know if Kofi wants to add up since you invited him to the
I think he
conversation.
should so that he can give the legal ones.
Yeah, so
Maybe- Yeah.
it's the I would only add a small I just add on to Auntie Yvonne's the nuance that she provided, where the when you are on your own thing, the law will call it you're on a frolic, that's a technical term, a frolic
Like
of
of
your
your own.
own. And again, another old case. I'm saying old case for the benefit of the audience because for law, 1971 is a recent case. You know,
Yeah.
Attorney General and Dade, that was a fire service case where somebody took a fire service driver. He used a vehicle to take a colleague home for a personal funeral wakekeeping. This one, the court ruled that it was a purely personal mission, and so the employer, that's the fire service, was not responsible for any for the damages. So that's just a little thing that I would add. So you can be on a work mission, and then you run a red light. It's not proper, but you're on a work mission. The employer can be held liable. But this one, they've not sent you. You've gone to take the car, go and pick your girlfriend or pick your colleague or whatever it is to go and shop or something like that. And then the thing happens. That one, the employer will not be liable. So that's just a little thing that I've had.
Okay. So on this same subject, where I know until you said that in the Ntiamwa case, the company was able to isolate itself from the situation because they took some reasonable steps. I mean, they have taken reasonable steps. So, for example, I just want to give an example where you have a policy, and I know this scenario is coming from a particular case where you have a policy that do not smoke, and then your employee goes and is smoking, and you've explained it at orientation, and still smoke close to where he's not supposed to smoke. Sometimes some of them will see they don't smoke on their own, they are still smoking. The policy it being in place and the sign being in place, will you classify or can we classify that as reasonable steps taken by the organization so that when it happens, it's only personal liability that comes in and the organization insulates itself from the whole commerce? I think I'll take a bite from Kopi and maybe Andy Ward.
It's inadequate. And HR people listening to me, please take note of this. You can have the policy and show it in court that you have the policy. The court will want to know, have you trained the staff on the policy? Have they signed on to show that they've read it, they understand it, and they would abide by it? That's why when we give the policies training at orientation, we need to get people to sign. When we give them the handbook, we need to get them to sign because there's a difference in having it and then implementing. And you have to show records in the court that you did the training on this date. These are the attendees. If it was online, take a shot of the video and then show that you've done it. You should have signatures of those who attended. And the training should not just be a one time, it should be something that goes on it. So you see some companies, they will do code of ethics training every year and they will tell you to sign. It's all part of the efforts to show that something has been done. You should also show that you have sanctions in place for people who breach your policy, and then where people have breached it, you have records that show what was done to them, of course using your policy and the tenets of natural justice, fair hearing, and the Nkosaswa things. The lawyers know that one. I won't go there. So it's not just the showing that you have the policy and having the sign. It's too minimal for the court to exonerate you. You need to show that the people know it, they've been trained. So in the First Atlantic case, if my memory serves me right, the HR was able to show that they have a zero tolerance policy on sexual harassment and other harassment. They've trained people, leaders are mandated to uphold it, and there's something they had signed that they will do it. Okay, so you need to show all of this to show that you have put things in place to prevent people from bringing you those liabilities. And then the court will look at all of that. They will also look at that person who conducted that action. Did that person, was he given adequate authority to do it? And it goes beyond just the job description. So when we tell managers at the beginning of the year as part of performance management, sit with your staff and tell them your expectations, not just the performance, the technical, but the behaviors you expect them to demonstrate, which must come through your values. It's not for fun, because those are some of the things that you can use in court to show that this one there is not me, it's Openi Menu himself who went to do it. So you check the managers giving the authority. You must show that the authority was given within a certain parameter, so that if the staff veered off, then the personal liability can easily come in. Yeah, so these are the few things you can do to show that you took reasonable measures to forestall that risk. Yeah.
Thank you very much, Auntie. In fact, you partly answered my next question, which that question I was going to give to Kofi to answer. So Kofi, maybe
And I give it to him.
I was just about to say, let her continue.
so Kofi, as an officer of the court, what will the court be looking at in making the decision whether we are saying that whether the act was in the course of employment, so that we are able to also put ourselves in the shoes or the things that the court will look at and then make a decision, because we also need to also make policies to that effect. And so that should be able to be the guiding principle for our policies and orientations and everything. So what, as an officer of the court, what does the court look, or what will the court be looking at when it comes to in the course of employment in relation to vicarious liability?
Okay, all right. And just, if you permit me, just before that, just some 30 seconds to continue from where Auntie Yvonne left off. And I think Auntie Yvonne should consider going to the bench and being assigned to the labor court, because that's what she said is exactly what the court is going to do. First, there's a duty on the employer itself, and the court requires you to have discharged that duty. And that is why you are required to show that you did this training, you did this, they have signed, they are aware of it, people have been held liable, and the rest. Now, coming closer to the question, that the direct question that you've asked me. First of all, there's a three-part test for responsibility. Okay. And I think we said this already, but I just want to structure it. The first element of the test is the evidence that there's an employer-employee relationship or master servant. Point 2 is that the employee has committed an act, a tortious act, negligence, assault, whatever. And then 3 is where your question comes in, that the act should have occurred in the course of the employment. Now, the test for course of employment is whether the act is an authorized task or an unauthorized mode of doing an authorized task. So I repeat it. Has the employer sent you? Either the employer has sent you, or the employer has sent you, and in doing the task that the employer has given you, you did it improperly. You satisfy the test. The employer will not be vicarious liability will not come in when nobody has sent you, and then you go and do your thing. And then because you happen to be somebody who is employed, you are not a member of the unemployed whatever association of Ghana. You want to intentionally bring in your employer. Yeah. So there's a limit. There's a limit. So that those are the boundaries of it. Your employer has sent you, and you are doing the task that your employer has sent you. Even if you are doing that task improperly, the basic thing is that you were sent. As for you not doing it properly, it's between you and the employer. The employer can deal with you. So those are the limits for the test.
Okay, thank you very much, Kofi. So just staying on you on this one, I know we've discussed this, but I want us to have examples. So I want you to help us with practical examples of employee conduct that can expose an employer to liability. Because we have a lot of CEOs, owners, HR managers on the platform. We want to maybe have some practical examples of conduct that exposes the employer to this liability.
Yeah.
We are looking at
Okay.
strictly the conduct of the employee.
Yes, yes. So, let's take a hospital scenario. The a health worker is an employee of the hospital, and you have a patient who comes in, and there's a lapse in the care that is provided to that worker. So, for example, you're supposed to draw blood from the, and we know they look for the vein, they stick it in you, they draw the blood. That if it's a blood sample that is being taken, for example, if in doing that, you cause damage to the person, to the person's nerves, to the patient's nerves, for example, this one is not a matter of perhaps the person has some peculiar characteristics that if you look at it properly, you should see. Because sometimes we tend to do things as a routine. Okay, 1+1 is 2. But sometimes some people are outliers. There's nothing wrong with them. They are just not the same as all the patients you've seen before, or you see on a regular. But absent-mindedness, you draw the blood the wrong way, the person gets hurt. The employer would be held liable. Or where you enter any establishment and the floor is tiled, and the cleaner, that's the employer's cleaner, is cleaning the floor, does not put a sign or take reasonable precaution to warn people who are entering the building that the floor might be wet, and then somebody slips. You see, in this second scenario, the person is carrying out a cleaning task on behalf of the employer, but they've not carried it out properly. In both cases, in the first case, it's not that there was something wrong with the patient or the nurse who drew the blood did anything wrong, particularly wrong. They did things the usual way, just that the usual way should not have applied in this situation. In the second scenario, the person did the cleaning in an improper way, and in both scenarios, damage is caused. In these two examples, you are going to be held vicariously liable. Even when you have an experienced worker, even where you have an experienced worker, and as an employer you fail to provide, Auntie Yvonne was talking about training and this and that and that. Even if you employ somebody who has 15 years experience, and here let's talk about this case, Corley and SEC. That's 1982. Corley and SEC. The court said that employers are liable for failing to supervise even experienced workers who are doing certain tasks. So yes, coming to sexual harassment, Section 175 of the Labor Act. What's this case? Professor Frank Novel, Shraj and Frank Novel. That's from, I think, 2001 or so. In this case, too, in fact, in this case, damages were found for emotional injury and loss of dignity following harassment. So these are, in fact, even in modern times, social media misconduct. You are handling many employers have social media handles handled by somebody. If we go to banking, errors, these little errors that are committed by the banks, they lead to losses. All these things are examples of ways in which employers can be held liable for acts committed by their employees.
Okay, thank you very much, Kofi. I believe
Kofi, sorry, Papa, let me add a bit to Kofi's own. I want to drill it down to my HR people. Take an issue like promotion. If you promote somebody without the criteria that the company is in policy, a staff can sue. And even though it was done by a manager, that manager's action can bring the vicarious responsibility. Or a manager sends a staff to go and buy food for them during working hours, which is not the work of the staff. You see, these little things, and sometimes we are safe because the typical Ghanaian doesn't like suing. We don't like litigation. And I'm happy that Gen Zs are changing that narrative. So, and I tell HR people every October, when you see the lawyers pass out, be scared, because these people passing out as lawyers, they have friends and families who are working with you. So I go home and tell my friend who is a lawyer who has noticed that, Yvonne, you are dull. What is the thing? I said, oh, my manager has transferred me to Accra. I'm okay in Tamale. I think the transfer is not fair. And then this lawyer friend looks into it, and before you see, they see an act of discrimination, and the company is sued in that capacity, and not even the manager who initiated it. Meanwhile, that letter was signed by UHR, so he will go to court on behalf of the company. So little actions and inactions within the office, negligence, like he's talking about, the floor is slippery, there's no sign of wet floor. And that's why these days you see most of these HSC officers are hot on their training programs. They've asked you not to climb the staircase double. You see the sign, you've been trained, and you are still doing it. Or and then a manager, you don't want to do it. So and then a manager tells you, I'm in a hurry, you're a young person, jump the things and go and get it. When that person's leg breaks, the company is liable. So it's not just the big things, small things like how we manage discipline, dismissals, office actions, like even sharing responsibilities, transfers, promotions. They can all bring this vicarious responsibility, liability, sorry, on our companies through the actions of the leaders. Yes, it can.
Then, Auntie Yvonne, let me ask. Thank you very much for the clarity, but let me ask you, as HR person, this means that we need to also be mindful of our employment, the people we employ, because I know there was a case
It's
that
the first step.
there was a case that
Negligent hiring. The lawyer will tell you. It's the first step.
the first step, yeah.
Yes.
The case that we discussed, and we're discussing with our colleagues, and it was the court indicated that if you employ a prankster, you brought that whole wahala on yourself. So, Auntie Yvonne, what's your comment on that? I know you started talking about it being the first step.
Yes. So when the courts say that you should know or should have known that this person can give you wahala. So the background checks we do these days, you will notice that it goes beyond just checking your former company and your school. We Google you to see who are you, what have you done before, what have you said before, and thankfully the internet never forgets. Sometimes we don't Google you directly. So I've noticed that Yvonne is Kofi's friend. So I'll Google Kofi to see what Yvonne said on Kofi's handles. It's all there. And this is also the reason why we do the onboarding. After the onboarding, determining the kind of person you bring in, and you brought the person in and onboarded the person, you don't just leave the person to be. Every action they make that is not aligned with your policy and the law, you must address it immediately. You don't say because it's Yvonne, let's leave it. She's a hardworking person. If she goes, we will suffer. If she stays, you'll be in court. You will pay higher. Okay, so from the onset, bringing the person in, you must make sure that you are bringing somebody who is technically competent to do the work and has the right attitude to exhibit the behaviors you want. Okay, it's very important. We were recruiting for a driver in one of the companies I worked in. And then our background checks, we noticed that in his former place, he was always having issues with the manager. He wasn't willing to take instructions. He's a bit older. So if his new manager is also young, this issue will be worse. Before we see, they've sent him to Atimpoku, and we will find him in Aplao. If something happens there, we will be in trouble. Long story short, we didn't bring the person in. And this is where I also tell staff and my career clients, your behavior outside the office space also can affect your getting the kind of jobs you want, because the company doesn't want to take on your risk because of the vicarious liability. So from at the point of bringing the person in, you have to check. The person says, I have a degree from the University of Ghana in mending pipes, and then you didn't check. You bring the person in, and the person is using live wire to do things that normal wire should do. 3 days later, somebody's house is bent down. You can't blame the staff. You are responsible. You can later sanction them based on your disciplinary code, but it's you, the company, because you didn't do the due diligence to check who you are bringing in. And this is not only for staff, even for our vendors, individual contractors, they can bring liability onto us depending on what we've asked them to do. So we also need to check who we are
Yeah.
bringing and what risk they can pose to us. You know, the person is a drunkard. Yes, at the interview, they won't drink. Nobody in his rightful sense will drink and attend the interview. But once you've picked that up, you need to ask yourself, can they do the job with the drinking? Can it affect your brand? Can it lead you to court? Me, the way I fear court. So if that is the case, don't bring the person. Don't bring at all. Yes.
Okay, thank you very much, Auntie Yvonne. For me, this clearly tells us that uh, we need to watch the space. And with the little knowledge I have in law, I can predict that the payout in this area will be huge. Kofi, what do you think? I think that a lot of people will be getting a lot of money. Companies will be spending millions. I wish you can do research in the space where we're able to identify how much companies are spending on vicarious liability. And then maybe research in the space
Yeah,
on
that would
companies
be
are dealing with
Yeah.
vicarious
Yeah.
liability.
Yeah.
Yeah.
yes.
And it's not just the cash, and Kofi will agree with me, the reputational damage. First Atlantic's name has been expunged from the case, okay, but it's still in our minds.
Yeah.
It's still in our minds, yes. So the reputational damage is huge. Everybody will think, oh, this place, when you go, they will sexually harass you. Oh, this place, their drivers don't
Mhm.
drive well. And it affects you, the brand. Yeah, yeah. Those there will be trying to leave you, and then new people will be afraid to join you. Bottom line, you can't achieve your business objectives. It's
Right.
expensive. Yeah.
Yes,
Thank you.
a good practical example is the upcoming, I think the upcoming reputation of Toyota Voxy drivers. You may be driving a Voxy somewhere, you overtake somebody who is driving slow and say, Voxy driver an airport. Or Okada riders. You
And
be
yeah,
on
mama.
your personal motorbike, which is like an Okada, and everybody already car owners already assume that you're an Okada who doesn't drive, who doesn't ride well. You
Oh,
know,
you see.
that's how reputation is developed.
Yeah.
So
Yeah.
I totally agree.
So, if you just joined us, we are having a conversation on vicarious liability. We are answering the question who will be held liable for the employer's action in the course of work. And so that's been our conversation. If you have any questions, there's a time to drop your questions. We are getting to the latter part of the conversation. So if you have any question, you can drop your questions. I'll be asking our panel, and then they'll be answering. But to Kofi, I wanted to ask this question. I wanted to throw this question to Auntie Yvonne, since I just saw somebody saying that they tag you as Madam Policy. I just wanted to have the
Okay, policy.
Yes. What does the policy say?
What does the policy say?
That's the policy say. So I wanted to ask you, how do workplace policy supervision and training influence assessment? Now we've had that conversation, but I want to ask you what policies or how can we draft our policies to take care of these things. Then after that, we can take Kofi on the same question.
So policies tell us what is allowable and what is not allowable, how it will be dealt with when it happens, or how you can have access, and who is responsible for what. So let me zoom down to a policy like sexual harassment, okay, where the policy may have a zero tolerance for it and avenues to report and seek redress. The HR or the company must ensure there is that policy in place. So it starts by identifying the various aspects that can put you in that capacity to suffer vicarious liability. Then you develop policies around them. Okay, so zooming down to sexual harassment, you have a policy on sexual harassment. Then the next, and once it's a policy, if after the HR has drafted it, it has to be given to a qualified lawyer. I am not talking about um, somebody who knows law, but somebody who is a practitioner with the ESQ, Esquire, by their names, to go through for you. They are not going to put the thereof in the policy, but they are going to look at your policy through the lens of law to see whether everything you have put there can hold water when something happens. Okay, then after that, the next step is to educate the staff. You start by the managers, educating them to know, and then the next one is the staff. Once you've done that, you give them a form to sign to show that they've seen it, they've read it, they've been taken through it, they understand it, and they will abide by it. So the policy becomes like an information point for you, the company, to let them know what will happen and what will not happen. But like we say, policy alone is not enough. So you need to train them. You need to also show what will happen if that particular action is breached, and that too must go according to the rules of natural justice, where you provide an avenue to hear the person and the sanctions are fair. You don't bring in sanctions after the crime has been done. The law does not have a retrospective effect. It must look forward. All those your law things. Uh-huh. So it must address.
With us, you are in the field with us.
You are pretending as if you are not in
Characteristics
the
of
field.
law. Yes. So you do all that, because sometimes people will tell you there's a policy. Okay, Papa, you take the policy and it's 7 lines. 7 lines. And then they tell you when it happens, we decide what to do. If the staff takes you to court, if the staff takes you to court, you'll be found wanting. So you need to have it in detail, and the center does the policy training as part of the legal way, where we talk about the policy having a policy statement, the guidelines, and the procedure. Okay. And then from time to time, you need to remind them of the policy and what it says. You can have beautiful ways of doing it. I use cartoons. You just pick a cartoon from Google, do the balloon speech thing, type the question there. Oh, is it true that here I cannot touch a woman in certain way? Then the answer by the HR is talking about the harassment policy and the terms, and then what will happen when it happens. Just a summary, so that intermittently they know. Then you also need to train the leaders on how to implement that policy. Ensure that when somebody is harassed, they can freely report and not be victimized and get the redress they need. And of all of this, you must have records. Most people lose in court because they've done it, but there's no record to show. And sometimes we quickly try to put down something. The courts will test the pen. They will test and know that this one, it was done recently. They will know, because don't forget, the court is there to ensure justice. So they make sure that you are not manipulating the system. So it's not enough just to have the policy. You must take people through it. The policy, yes, will reduce your risk, but it will do so only when it is implemented. And you can only implement it when the people know it. If they don't know, even though they say the ignorance of the law is no defense, I'm telling you that with this particular policy thing, you rather in the HR, you will lose. The company will lose because you have the policy, yes, but they don't know. And staff can say in court, I don't know. So what is your evidence? The thing they signed. What is your evidence? That WhatsApp messages you put on the company WhatsApp page, the training reports and the attendance records, then you vindicate yourself and you are cool. Yes. So
Thank you very much.
it
And
starts by identifying the areas, developing the policy, implementing the policy by training them and intermittently reminding them of it. And then when there are breaches, sanctions are done through the procedure laid down, and records are also kept in that same purpose. Yeah.
I have no doubt why the person calls you what the policy says.
What does the policy say?
What does the policy say? Yeah. Thank you very much. I'm confiding you
Papa,
to add.
let me just, yes.
Yes.
In fact, the content of what that Yvonne has said, I cannot edit it at all. The only thing that I will say is that all these things that she has said, we should understand it as the duty of the employer, because if an issue comes up in court, unlike what we may be used to of innocent until proven guilty, when it comes to vicarious liability, it is the opposite. So once your employee has done something, you are going to be held liable unless you can show that these are the steps that you took. That's how we should understand it. That's how we should understand it. And there's something that I don't know if I'm not sure if anybody has already asked that question, but something that has been asked me before is inspiring me to say this thing, that even moving on from being held liable, after the employer is held liable, in many instances, they then go back. I said earlier that it's between you and the employee. Many employers go back and then sometimes they will deduct the damages from the employee salary or entitlement or whatever that it is. It is important to note that you cannot just go and do that willy-nilly. You have to, as Auntie Yvonne was saying when she was talking about natural justice, this is an example of where natural justice should come in. So the fact that you have had to pay because you were taken through the process does not mean that you should just go and deduct from the employee's salary. What you're actually supposed to do is that just as you were taken to court or you were taken through a systematic process to arrive at a conclusion that you should pay, you should also take the employee through a systematic process, giving them the opportunity to be heard, follow fair disciplinary procedure before any deductions are made. I just wanted to say that before I forget it. It may come up again, but in case it doesn't, I just wanted to put that out. Thank you.
Thank you very much. In fact, the angle is very, very important. Especially employers like to everything want to touch salaries, and it's good. It's good
Yes.
that that comment came in. I worked in the factory setup for a long time before going to consulting, and this was one of the major problems in the FMCGs. I think I consulted for ILO briefly for the garment factory industry, and this was a major thing, especially when they were going for certification for SEDEX and ISO. It was a major flag that we're flagging across. Deductions done anyhow, and so it's
Yes.
good that you raise that up. Before I come to our concluding part questions, which will look at the way forward, how do we mitigate? What do we do to ensure that we are not we don't find ourselves or organizations do not find itself spending a lot of money? I know when it comes to labor law conversation, organization feels that the bias has always been to the employee. employer. But I know this conversation, the bias is more to the employer than the employee. And so I believe that the CEOs are enjoying this conversation. But just to take some few questions that have been asked before we come to the final part. Someone asked the question, I think this one has been addressed. No, this one has not been addressed. In fact, it was one of the questions I wanted to ask. Vicarious liabilities and independent contractors. For example, you have contracted a security firm to handle your security for you, and then you ask the security guard at post to do something, and it costs someone or another employee some form of injury. Who is held liable? I know this was one of my labor law questions we answered.
This is one of the things Auntie Yvonne was talking about this in the beginning. I think we should give her the opportunity
Yeah.
to repeat.
So I was preparing for this session, I was watching some YouTube videos of vicarious liability. And one of the videos, the company had contracted an independent security company to man its security. So a staff who had been had been terminated felt the termination was not fair, so had come to the office to seek redress. And this security had been given information that when Osumesi comes, don't let him in. So he was showing body holding, preventing this guy from entering, and in the scaffold broke the hand of the guy.
Oh,
And then the guy sued the company. Remember that when we started, Kofi talked about the cost of employment. Is there a contractual relationship between the company and the security company? Yes. So as far as they are doing something for you on your premises, dealing with your customers, which is your external customers and your staff, you need to ensure that your risk is managed. They don't bring you any liability. So your food vendors, those who bring you food, if they bring the food, it's not well done and your staff are running, they can sue you as the company, and you have to seek redress and later maybe deal with that contractor. And that is why we do the SLAs, the service level agreements. It must be part of the terms you have with the contractor for them to know how to behave whilst they are doing your work, because some of their actions can bring you this liability. Yes, so the contract you have with them,
yes.
you spell out all these things in there. Yeah.
Yeah. I don't know,
Yes,
completely.
Papa, and to add to that, the after, I mean, let me just say this. So if I go to a bank and they tell me not don't park here, you know, the contractor security tells me not to park here, go and park here rather, and I park there, leave your key so that when somebody is moving, we can move it. Or, you know, I enter the banking hall, the person is directing me. You know, sometimes when I go to the banking hall, the security men themselves will be directing you, doing
Yeah.
things for you, or, you know, heading you in this way or that way. If something happens, the customer is not going to look for who employed us, look at his uniform, look at his badge to go and sue the company. No, they will sue you. What you can do is that based on your SLA or the relationship between you and the contractor, the contracting company, you can now go and, you know, just their neck. But that will come separately from the responsibility that you have had towards the customer or towards the victim. That's just a note that I want to make. So just as you can go and hold a disciplinary hearing for your employee, your direct employee, after he has caused you to go and make payments out for vicarious liability. In the same way, the contractor, the independent contractor, you can deal with them. But as for the vicarious liability, you will be held for it.
Correct.
You will be held for it. Yes.
Thank you very much, Kofi. We have about 20 minutes, but I want to make sure that we answer all your questions before we have the concluding remarks. So there's a question from someone. I think, Auntie Yvonne, you addressed it, but let's see. It says, what Please, what happens when an employee sends another employee the Wache conversation, sends another employee on the personal mission of, of the sender, and something happens to the one running the errand? Will the employer also be held accountable? The national service people who we know, the people normally send to go and buy Wache, and they get injured. What happens?
Yes, you can. You can, because you see, it comes back to the three tests that Kofi mentioned. That staff who had the accident, does the person have a relationship with the company? The staff who sent, the one who asked the individual to go and buy the food, is there a relationship? Yes. Is there an authority giving them to do that thing? Yes. Was, you see, he talked about the frolicking. This staff is not frolicking. He's been sent by somebody in authority to do
Yeah.
something.
Yeah.
So it will put that thing on you. So that is why sometimes when HRs are asking for certain things to be done and managers are saying we do too much, I laugh, because once again it comes back to the fact that Ghanaians don't like suing. But if the staff were suing like it should be, everybody will be clear clear. I don't know the English for clear clear. Like ubedu lane, you get it. Uh-huh.
Everyone will be
Because
alert.
when you sent that staff who has just joined you, has not been trained on the photocopy machine to go and photocopy something, then in the course of the photocopying the paper got jammed, so he tried to remove it so that he can print your thing for you, and in the process lost her little finger. You are responsible. And vicarious liability has been established to protect staff so that you can do your work and do it well, knowing that whatever action I take is the company that will bear the cost. So that I will do it with no fear, knowing that if something goes wrong, it's the company that is responsible. So that is why if you even take companies who have systems, ERPs, I'm talking about software, the accesses are in different levels, because if you give somebody access that allows the person to steal money, yes, the money is stolen. Clients will sue you, the company. They will sue that staff. But you gave them the opportunity. The work you gave them provided avenue for them to do that thing. So proving it in court is not that easy. The driver you sent to Atimpoku who continued to Aplao to visit the girlfriend and mistakenly drove the car through some people drinking and killed two people. You can't stand there and say that you didn't send them to Aplao, so you are not responsible. You need to prove it. Is there a mandate? So that's why these days we tell people reduce the verbal instructions and conversations, because you have to prove that it was to Atimpoku you sent the driver, not Aplao. What shows? So that person who is going to buy the wache, a staff sent by the finance manager who got the issue, it is the company that is liable. They can sanction the finance person later, but if this staff wants to sue, it's the company that will bear the brunt.
Their liability. Thank you very much, Auntie God. Just to also
You
say that if we are not able to, maybe you had a question we end and the question comes later. We so there's a special session, an 8 week HR and the law session, where it's purely virtual this year. The first course starts on the 10th of April, and so you can register. You can reach out to us, register, and then join. That one we go detailed on other issues aside vicarious liability. But just to read this question, this interest. This one is not vicarious liability question, but it's on performance. So the Patrick is asking, in case you're not given the right resources, and then you're not given the right resources, pressure was put on you to work, and you are not able to work as or give the needed result, and you are sacked. What happens for non-performance? What happens? Kofi.
Hmm. This is, I like the question. Yes. So it is the duty of the worker to, once they've signed the employment, they've entered into the employment relationship, to make themselves available for work. No doubt. It is also the employer's duty to train the worker and provide them the necessary tools that they will need for their work. Let's put that on one side. Now, apart from that, if the reason you are terminating somebody is for non performance, then that is when someone like me, if you come to me, I will echo Auntie Yvonne and say, what does your policy say on performance appraisal? Because, and I always take the opportunity to let those of us that have never had any interaction with the law know that the law is not about the truth necessarily. It is about what you can prove. So the laws in court, the concept of truth is what is proven. Outside court, we always say that the concept of truth is something moral. But what you can prove is what you take to court. So if the reason for this termination is non-performance, you have to prove the non-performance. And how are you proving the non-performance? That's when he had a job to do. He was made aware of what the job was. Our policies and things show the kinds of sanctions for various infractions, including if you don't perform. Maybe first you get a warning, you'll be put on probation, whatever. All those. If you don't have any of that, the worker indeed may be a non-performer, and some of them, well, even if you train them, even if you did everything, they will still not perform. But once you cannot prove that you have done that, you have done your part as an employer, you are likely to lose that case. So to recap, it is the employer's duty to provide the tools, the resources that are needed for the work. And if you are going to fire somebody for non-performance, it should be proven. It should be proven. That's what I would say. Thank you.
All right, thank you very much. From Lucas, he says, are there any community we can join for resources to stay updated as HR professionals? Auntie Yvonne, this one day, I'll leave it to you.
Thank you for asking. You can join the Ask HR network. You can join if you are certified or reading the course to be certified. You can join the Association of Certified HR platform. We also have the HR network. With the Ask HR and the Association of Certified HRs, every week new things are going on. You can also follow the center, HRCC, on LinkedIn. They put wonderful stuff there, on Instagram. And then I would also encourage you to get HR mentors, people you can go to. Now you have Kofi here. Please don't joke with him. He's a heavy load. Trailer and casa. So that once a while you link up with him. Yes. So these platforms are available. And the center also runs a lot of these webinars. So keep following us and don't miss it. Yes.
So thank you very much. The next question from Evan says, who will be held liable when a worker take alcohol 2 hours before closing, which is provided by the company in their monthly drink cup, and on his way back home, he got an accident?
So these are the dicey ones. Okay, so you will see that in some company parties, they will say you are entitled to 2 bottles of alcohol, 3 shots of liquor. It's all because of that control, so that you operate within a certain consciousness after drinking. So when you notice at staff parties at some point the drinks are taken away and all of that, is because of these reasons. Except where you sleep in that same hotel, that one there, you can drink till. So when it's not controlled, if it cannot be proven in court, once again coming to the truth, the company is liable. And this is not just for office parties, even the WhatsApp platforms, the company WhatsApp platforms we have can lead to a company suffering this liability, where somebody says something wrong or publishes a picture have not asked them to publish. So somebody's wedding invitation, you need the person's consent before you put it there. He can sue you for what do you call that one? Is it libel or whatever? Defamation, that thing.
Defamation.
Yes, they can. And once again, people don't do these things because it's like, oh, but this one too, what is it? They put your wedding picture for there, so what? I be you alone when you do wedding. But the time is coming, people will sue. People don't care. So we need to be careful. So if that person goes to the office party and he wasn't controlled, he wasn't supported to get home safely, and it was obvious that he was intoxicated, he may be liable. The company may be liable. But once again, the facts may have to be looked at. It's not a straight yes or no.
Yes or no? Okay. This question has been answered in a different way, but the way the technicality that I'll ask, it says in a scenario like a hospital, and this question is copied. In a scenario like a hospital, and a road nurse is assigned to pharmacy, and rights and duties of employer can I reassign you, but I know there's a but there. Is assigned to pharmacy to work, and an error occurs. Who should be held liable?
I
This one,
think
I'll not
Kofi
be,
said this.
yes,
Kofi carry
I'll not
on.
be wasting this. It's the employer.
Yeah.
This is the employer.
So Roland, the employer.
Yeah.
Susan
If you go
also
and
said,
place, if you want to place if you want to place a square in a round hole, then you have to make sure that you sandpaper the edges of the square so it wants to become round.
I like this
Kofi
analogy.
mean.
If you don't do that as an employer, you are just looking for trouble.
Yeah.
All right. So Susan Asibe says, if a healthcare personnel who is on probation makes who is on probation makes it. Let me see if I can get what he's trying to say.
He's being bitten. So he's the worker,
Oh, who's
the
been
health worker
bitten?
is bitten by a dementia patient.
Oh, okay. And he shouts on the patient out of pain. If someone secretly records the incident and use against the staff and reports to the police, should the staff be sacked, knowing that the staff, knowing that staff while investigation is going on?
Okay, let me
Oh,
take this. Let me take this. This might not really be vicarious liability. In
Yeah.
fact, in this case, the employer can actually take action against whoever. I mean, of course, it's a dementia patient, so I mean, the fact make it a little, but the hospital will not be responsible for compensating the patient because of the shouting, and the one who recorded it may actually end up in trouble for the
yes.
recording. So it's not it's in fact it's a the what the consequence of this is embarrassment to the hospital because the public may not get the full benefit of the context from the short from so and you see you can actually end up in trouble for that recording. So as for this one, the staff should not be sacked. The staff should not
Okay.
be sacked.
All right. So the next question, Louisa, says, what does the law say about a case where an HR who has worked with the company for 3 years has been sidelined but not given any letter of termination? An employer informs the staff that he has no HR department in his company. This one is a you. I remember when we asked
This
this
one
question.
is not vicarious reliability, the
That
liability.
me, James. So, Kobe, this
When they all pay legal advice, but see Kofi, you collect only small money. Okay. Because he has to ask you certain questions. Do you have a
Yes.
contract of employment? What are the terms? Were you given a term? It's a lot of things. So see Kofi, okay. He is very kind to our customers. He will be sweet to you, okay.
All right. The next question from Marietta is that at what point in the HR recruitment process is appropriate and legally safe to consider hiring individuals with criminal records? whilst ensuring that the organization is protected from negligent hiring and vicarious liability? This question is a serious one.
I don't think
Hence,
there's anything legally safe by employing somebody with a criminal record. So, when we say we check your criminal record, it doesn't mean that if you have one, we won't bring you. I remember one time we had a reference check in one of the places I worked, and the person was sacked because he stole from us. Okay. And then when we stated that he was dismissed because of stealing, theft, the company went ahead to recruit him. But what I later discovered was that in his work, even though he would be engaging the media and all of that, they never made him handle the media payments. Someone else was handling it. So they were mitigating that risk by not exposing him to money. So the checks, when you get the information from the police or the criminal record from the former employer, you need to look at what you do as a company and how that character can affect you by bringing you risk. I'm a believer in second chances. So I can give you a second chance, but it won't be an open letter because I need to also protect the company from the risk. So, for example, if you were in the treasury department and that is where you were able to steal, you come in now and you are in operations. You don't handle money, you don't handle anything, paper money or physical. Yes, but it's a risky thing to do. So, as practitioners and workers, we should be careful the kind of reputation we leave in our companies because it can haunt us. Yes, it can haunt us.
yeah, this question is simple, and I know it's a yes or no question. Can the staff sue the employer?
Oh, Kofi, this one there is in your line.
In fact, this one I think that we should even let Papa himself answer it. The answer is yes.
Yes. So, Susan, the answer is yes, but also no. You're going to sue your employer, so be careful. That your ground should be solid, because after that, you know
Yes.
that when you are going to sue, you should also tender in your resignation letter, depending on the grounds.
Yeah.
Depending on the
And
I
even
always
grounds.
say,
even where the court says you should be reinstated, they can
Yeah,
do constructive discharge to you. Your
yeah,
office will be near the genset, so the smoke and noise will
yes,
drive you out.
yes,
all right.
yes. Having
So
the
the
right
next
is
question
one thing, how you exercise it is another.
Yeah,
yes,
yeah,
yes.
yeah.
The next question is, if an employee steals in the course of his work, meanwhile the employee had put in resignation some few weeks, how should this be handled? Auntie,
Oh, this one is not vicarious. Oh.
not vicarious, yes.
You've tendered in your resignation, and whilst you are waiting for the time to elapse, you still. Once you've not left, you are still a staff. So the whatever has been put down in your disciplinary code to handle theft will be used. And depending on the graffiti, they can even decide to report to the police and make it a criminal a criminal suit. Let me put it that way. So if you've tendered in your resignation, hold your peace and go quietly.
Mm.
Yeah.
Emma, this your question is a general question. He's talking about you are using your car on an errand on behalf of the organization, which organization is aware. Then car got an accident in the course of work, and then the company decides not to pay the maintenance. What do you do?
What does the policy say on using personal cars for official work? Uh-huh. Because this one is not just law. You have to look at it. Do you have written authorization for using your car? Sometimes you may not have the written one, but there's something that the law has. They call it acquiescence, where they've done it you've done it continuously. It's become like the practice. Do you have some evidence of that? Then you can make a case, but that also depends. The several facts have to be known and considered before it can be determined whether the company should pay or not, because it could be through your own negligence. Uh-huh.
Yeah.
So that is not a straightforward answer.
Our time is up, but I'll take about 3 questions, and then we end here. And those who are interested, those who have more questions, we'll share our consulting number. But if it is one that has to be done on consulting basis, we will have to have the conversation on sidebar. Until you understand sidebar conversation, we'll see how we can put this in the right perspective. So,
Yeah.
and I love this question. It says, if two employees are fighting over a lady at the workplace,
I was waiting for
and
you to
one
read that one.
is this still my liability?
This one, Kofi, you take it too. I think the frolic thing
So,
comes in.
Papa, this is an example of a frolic of your own. And in fact, this question should help us understand that you can be on a frolic of your own without leaving the workplace.
Yeah,
Because there are several forms of employment. Some people's employment is on the computer. But the computer, you can use it for your employer's task. You can also use it to check your personal email. So you can be on a frolic of your own without leaving the workplace. And for something like this, it is not. It's actually it's between the two. It's between the two employees and maybe the lady. Maybe she need to explain what makes her so attractive that people are fighting over her in the work. That's just a joke.
so this one is talking about you send someone, for example, you buy something online, the company buy something online, and the delivery driver is bringing it to the company, and gets an accident on the way. Um, who is liable? I think this one is a simple one. The delivery driver employers that's where the conversation will be, not
Yeah.
you, that's the person. Yes, I am learning small small. Anyway, so
Exactly.
the next question, this one is more on performance. Somebody who presented fake, and I know there's a classic case on this one where somebody presented fake documents as when the HR manager has found out that it was fake documents, but has reported to the country manager, and the country manager is saying that this guy's performance is good, and so we need to retain him. What does it say? What are the pros and cons of such situation? I know there's a classic labor law case.
So the employee presented fake documents, but it's a high performance, so
High
they
performance.
want to keep the person.
Yeah, the country
Let
manager.
that this one, I will not go by law. I'll go by quote and unquote common sense.
Listen,
If you still want to keep the person, let the person withdraw those fake documents. It's unethical anyway. Let them withdraw the fake documents, and then in the ideal case demote them, because they are taking pay for what they are not qualified for, unless you have enough evidence to show the experience beyond the educational qualification required. But if I want to be myself, my Yvonne ethical self, I will say it doesn't matter. Dismiss them for presenting false certificates, because it's against your rules, and it will serve as a good deterrent for others that your experience alone is not enough. You see, this vicarious liability we are talking about, it forces companies and their leaders to look beyond just performance. Yes, you are a sales manager, you are bringing the monies in, I'm happy. But in the bringing the money, you are exchanging things that can easily send us to court in the process. In that case, I can't keep you. And that's why most performance management systems, the appraisals, check performance and check behavior. So in this case, I would say that they should just terminate the person, because another staff can bring it up and it will be difficult to defend. Yeah.
yeah. Thank you very much, Auntie Yvonne and Kofi. It's been an insightful conversation. I would
Yeah.
like to take our final words a minute, 30 seconds, a minute each, on in conclusion, what should companies do to safeguard themselves?
Should ladies go first?
Um,
Yes, Auntie Yvonne.
Okay, so In companies through their agents, that's the workers, especially the leaders, we have a responsibility to reduce vicarious liability because it has different implications, like we've seen the cost, the reputation, staff morale, even not achieving your objectives. It's not just about liability, it's also about our culture and accountability, ensuring fairness, transparency, all of that. So we should not just have the policies, it should go beyond having it. We should implement it, we should train our people, and we should be seen to be fairly administering the policies. Vicarious liability, yes, the company is responsible, but in some cases, if the facts are proven, you, the individual, is also responsible. So let's not hide behind it and misconduct ourselves as workers. So that's the bit I'll end with. I've had a beautiful time this afternoon with you guys and ladies. Yeah.
Thank you very much, Auntie Yvonne. Kofi,
Yes.
just a second. Those who want to know more about HR Certification Center, right after Kofi will brief you on certification. So please hang on. Yes, Kofi.
All right, thank you. And yes, just like Auntie Yvonne, I have enjoyed this session with everyone, the questions and the rest. And I'm grateful for the questions because the questions give us the opportunity to explain further. But I just want us to live with this understanding that vicarious liability is the cost of doing business in modern times, in the sense that now it is clear that the courts, the few cases that we mentioned, especially the Supreme Court, is not going to allow enterprise risks to be transferred to victims. Enterprise risks such as incompetent workers, making mistakes on their job, unlicensed vehicles, those kinds of things. Their incompetence is not going to be allowed anymore to be shifted onto the victim. And so, because of that, I'll urge each one of us, especially those of us that perform HR functions, this week when we go back to work from Monday, let's just do a liability audit. A liability audit. Looking with the wisdom that Auntie Yvonne has given us, let's go back, look at our policies, where they need updating, where they need more flesh, and all of that. These are steps that we can take, to shield ourselves from vicarious liability. Let's also ensure that supervisors are trained properly, trainer of trainers programs, especially to recognize that the biggest defense or the main defense that an employer, an organization, an institution has against vicarious liability is that the employee or the worker was on a frolic. And so everybody should be trained to recognize what a frolic is. And that should help us. Thank you very much for everybody.
Thank you very much. I have really enjoyed the session, your expertise, the questions from our participants. I saw one of our participants coming from the UK. That means that this session has been an international session. I hope the next conversation will have some international conversation in there, and it will be good. Thank you very much. We are grateful that you were able to join us. Quick announcement before we have our advert school. First, I am Papa Usubewa. I wanted to introduce myself last. I happen to be the chief servant for consulting and programs. And so if you need any consulting service, in-house training, anything, you can contact us on 059 944 4999 059 944 999. You can contact us. For certification information, the number is scrolling on the lower part of your screen. You can contact us for detailed information on 0244 122 855. 0244 122 855. Our next cohort will be taken off on the 14th of March. And so quickly get in touch and let us add you to the next cohort. Also, just to say that this HR and the law, this session is a free webinar. There's a detailed conversation on HR and the law, which is not just limited to HR managers, but also CEOs, SMEs, anybody that deals with people management. And so it's an 8-week course. Our first cohort for this year will start from the 10th of April. It's a Saturday, Sunday virtual training where our facilitator Kofi is also on, taking some of the modules for us. It's an 8-week program. The payment terms are also flexible, so you can contact us on the consulting line. That's the 059-9444-999, or even you can also call us on any of our contacts that you see around. You make the inquiry, they will link you up to me, and we'll have the conversation on how you can register for it. We also run some webinars and workshops, in-house workshops for your organization, and also run some, we also have public trainings that we do. On Friday, we'll be having a seminar for a breakfast meeting for all HR professionals. And so go on our socials and you find all the information you need on that. It's a breakfast meeting, so it's a morning session. We're inviting everybody, not just HR managers, but anybody who manages people. Come and let's have a conversation on HR issues. On the 26th, which is the Thursday to the Friday, we have an hour workshop, an hour webinar, free webinar on communication, effective communication. And we are looking at the impact of communication on performance. And we have seasoned facilitators on it. That will culminate into our coaching session on the 26th to 27th March. I'm sure you will get all the information on our social media platform. So for more information, visit our social media platform on Facebook, Instagram, Twitter, LinkedIn. You get all the information you need on all our programs. And you can also call us if you need any clarity. Thank you very much. Silas, my Chief Marketing Manager, is there anything, Officer, is there anything that you have for us before we end the session?
All right. Thank you very much, Papa. And thank you to our distinguished speakers. So for those of us who want to know more about the HR certification programs, our next cohort, just as Papa rightly mentioned, will be on the 14th of March. That is in 2 or 3 weeks. So if you want to have more information, kindly reach out to us on 0244-122-855. The number is currently scrolling down your screen, so you can just capture it and then reach out to us. After the session is over, we are going to play a quick ad, which is going to give you more information about the modules, that is the kind of programs and then the topics that will be treated. And you have more understanding on the duration, what you have to do, and some of the necessary things you must put yourself together in order to join this program. We are grateful for your time, and Papa, thank you for moderating such a good session. Do have a good evening.
Thank you very much.
Always remember, what does the policy say?
What does the policy say? And that's our tagline. I think that's our tagline for HR law. What does the
policy say? Yeah.
Have a good weekend.
Enjoy the rest of the evening. Thank you. Bye.
Certification Center commits to a higher standard. Certification Center commits to a higher standard.
Why do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.